The appeal court sitting in Abuja in the appeal of Dr. Asue and the PDP on Thursday ruled in favor of Senator Monday Okpebholo in Edo governorship case, as it upheld Monday Okpebholo's cross-appeal against Asue and the PDP. BTV News senior reporter Best Orator reports that the court has squashed, overturned and expunged the tribunal's admission of evidence of 133 BVAS machines submitted by Ighodalo and the PDP. The report.
Shortly after announcing the appearances, the three-man justices of the Court of Appeal said Appeal 1, which is the main appeal of Asue and PDP, and Appeal 4, which is the cross-appeal of Governor Monday Okpebholo, will be delivered together. Reading the lead judgment, the judge said on 21st September 2024, the first respondent, INEC, conducted the governorship election and declared and returned the third respondent, Senator Monday Okpebholo, as winner. Dissatisfied with the outcome of the election, the appellant approached the tribunal to challenge it. He said one of the grounds of the petition is non-compliance with the Electoral Act. The court said the tribunal ruled on the matter on 2nd of April, where the tribunal delivered judgment in favor of the APC and Governor Monday Okpebholo. And also dissatisfied, the appellant approached the Court of Appeal with a mission for the appeal court to overturn the tribunal judgment. The court said, having taken the pain to go through the cross-appeal, where the appellant cross-respondent claimed that the cross-appeal was filed out of time and cited past authorities that only 14 days is required by law for Okpebholo to file a cross-appeal. In the cross-appeal, the court said Owonikoko SAN, who represented Asue and the PDP, on the day of the adoption of final written addresses, urged the court to sustain the objections of the cross-appeal, particularly as Okpebholo and the APC did not provide the necessary document in the cross-appeal. The court said Onyechikpe Asue SAN, counsel to Okpebholo on that day, however, told the court to dismiss the objections of the PDP. However, the Court of Appeal said the complaint of the appellant cross-respondent is strange and misconstrued. They said when the documents are already before the court in the main appeal, there was no need filing separate documents. The court said the cross-appeal is not a fresh trial, as it was a continuation of the appeal. They also said, having considered the arguments of party, it was their view that the cross-appeal was not targeted as interlocutory injunction, maintaining that a single ground of appeal is sufficient. The court said Asue and PDP also complained that the records of cross-appeal is not complete. The court said where there is an appeal and cross-appeal arising from the same disputes, and where there is already a record of court transmitted by the main appeal, there is no imperative reason for there to be another record of appeal, adding that one valid record of appeal is sufficient for both the main appeal and cross-appeal, and therefore both parties are bound by the record of the court. Therefore, the court said no merit in the objections by the appellants and cross-respondents in regards of the unfounded allegations of complete records of cross-appeal. The court said the grounds of the appeal is based on the fact that the election was invalid by reason of non-compliance to the provisions of the Electoral Act 2022, and that the second respondent, Senator Monday Okpebholo, was not duly elected by majority of lawful votes cast at the election. The Court of Appeal said there is nothing in the petition laid before it that the election of Senator Monday Okpebholo was invalid. He said the pleadings of the appellants did not state or indicated that there was a direct infraction. The court said the tribunal or the court, as the case may be, determines that the candidate was returned accidented or not validly returned on any grounds, the tribunal or court shall nullify the election and order INEC to conduct a fresh election not later than 30 days after the day of dismissal, and if an appeal is not filed against the decision of the tribunal. He said the appellants, after pleading materials facts to prove the grounds of non-compliance, ought to have concluded their pleadings with relevant documents. The Court of Appeal noted that the appellants, after pleading materials facts, they left the material facts of proof of the first ground in the appeal and said the tribunal should have given a decent burial to the paragraphs in the petitions of the PDP and Asue. The judge said the appellants, having pleaded that the election was invalid by reason of non-compliance, were banned by their pleadings, saying that the party who claimed that the election was invalid cannot now also be asking the court to declare him winner, and that was what PDP and Asue prayed for, and the Court of Appeal described it as strange to the Electoral Act 2022. On the issue of BVAS machine, the Court of Appeal Appeal said the tribunal was in grave error when it admitted the beavers machines in evidence. It said the practice of tendering documents from the bar is strange in law practice and that only documents which parties consent to shall be tendered from the bar, not the beavers machines in this case. It said the admissibility of 133 beavers machines by the tribunal was a miscarriage of justice and the exhibit, that is, the beavers machine, was thereafter expunged from the records of court, meaning that the petition is now standing on nothing. Judgment of the cross appeal was delivered. Then came the main appeal of the PDP and Asue. The court said the case of the appellant is on Form EC 25B, which they claim were not filled by the first respondent INEC, and argued that there was no need to call oral evidence to prove non-compliance with regards to Form EC 25B and prayed the court to nullify the election. Whereas, the respondent said that the Form EC 25B is not the form required to fill the said electoral materials and that the petitioner at the tribunal should have called oral evidence to prove their case. The appeal court said the position of the tribunal is dismissing for the petitioners not calling oral evidence on the issue of Form EC 25B aligns with past Supreme Court judgment. The court said there was need for the petitioners beyond mailing tendering documents to have called oral evidence. Following Supreme Court precedents, the court said the petitioner is expected to demonstrate in oral evidence and to lead credible evidence. The petitioner should have led oral evidence since the document tendered did not manifestly prove the allegation of non-compliance. The court maintained that the beavers machine were dumped on the tribunal without demonstration, that the appellants were supposed to have called oral evidence because it was crucial to do so. One of the key requirements of proving overvoting, according to the court, is missing from the case of the appellant, as the beavers machine being one of the key evidence and also the bottom of the case, and having been expunged, the bottom of the petition has fallen, that the majority of the documents tendered by the appellants were not eligible and do not bear the stamp of INEC, which made it difficult for the tribunal to ascribe any probative value to them, and that the appellants did not call any significant number of witnesses to prove the allegations against the respondents. The petitioners who contest the legality of vote cast in an election, according to the court, must tender in evidence all the necessary documents, and it must not stop at tendering documents, but must call witnesses to testify to the legality and lawfulness of vote cast, and the witnesses must be those who were there on the day of the election and witnessed what transpired, and they must not pick their evidence from eyewitnesses, as they must be eyewitnesses themselves. The court said it was unwise for the petitioners to only tender documents. They must lead evidence on how the non-compliance substantially affected the outcome of the election. The case of the appellants, according to the court, is that they presented 19 witnesses with the absence of Forms EC8A, which is the primary document in the process to prove the case, maintaining that documents uploaded from IREF are simply meant to verify what is contained in the physical result of Form EC8A obtained from the polling units. The court said the appellants brought witnesses who testified about what they knew nothing about, especially PW1 to PW14 and DOP documents in the tribunal. He said on no account must a cancel DOP documents on the trial court. The Court of Appeal subsequently dismissed the appeal of the People's Democratic Party and Asue, saying there is no merit in the appeal. At the end, party leaders and others addressed journalists.
This is not a news to us in Edo, but Edo people voted for Monday Upheld-led administration, and all these distractions would have been avoided. But at this point, I want to call on my elder brother, Asue, to embrace this judgment, and let's come together as one family to develop Edo. That's what we stand for.
Now, we now have a double victory. Governor Monday Upheld has again been victorious in this appeal, and the Court of Appeal has aptly captured it by saying that their petition in the first instance lacked merit, as they did not prove their case of overvoting and no compliance with the Electoral Act.
Do we agree with the judgment? Of course not. We think even the judges, especially when they started talking, taking out their eyes from what they wrote, you could see some elements of bias in what they were saying. However, we would request that our members stay calm. We will get the CTC. The lawyers will advise. The lawyers will go through it. We will go through it, and nothing stops us from heading to the Supreme Court.
How can a petitioner say that an election should be nullified. One breath. In another breath, they are saying that they should be declared the winner. And that it was a mere academic exercise. And so, I saw the appeal was dismissed on the merits. And I said it before this time that the issue of beavers were mainly, they came and dumped beavers at the tribunal. Though the tribunal at their wisdom were admitted, but the Court of Appeal in the cross appeal of the governor, they upheld the cross appeal and threw away those beavers as lacking many, and they threw them away. We're happy today.
The appeal of the Action Democratic Party and Accord Party against the judgment of the tribunal were also dismissed for lack of merit. Edo State APC Secretary Engineer Lawrence Oka said from the judgment it was obvious that the appellants wasted the precious time of the courts.
The first one, that of PDP, they don't have any locus at all. They just keep to court because the premise on which they alone their foundation have collapsed. They said the election was invalid, and yet they want to declare the winner. You can see that it's following the law. They are not even following the law. They only came here to gamble. And did Isha acrobatic.
All four appeals brought before the Court of Appeal here in Abuja were dismissed and judgment delivered in favor of Senator Monday Upheld. For the petition of the People's Democratic Party and its candidates in the 2024 governorship election, Dr. Asue, two things stood out. The Court of Appeal said that the tribunal erred when it admitted in evidence 133 beavers machines that were tendered from the bar, and referring to certain paragraphs of the appellant's petition, the Court of Appeal said that those paragraphs ought to have been given a befitting burial. And another thing that the Court of Appeal said that was of interest to people was the prayers of the appellant asking the Court of Appeal to declare Dr. Asue as the winner of the September 21 Edo governorship election. The Court of Appeal said they could not grant such prayers because, in one breath, the PDP and Asue were saying that the election that brought in Senator Monday Upheld was invalid by reason of non-compliance to the Electoral Act 2022 as amended. And on the other hand, they were praying the court to declare them the winner. And so the Court of Appeal says, in saying that the election was invalid, that automatically means you cannot be declared as the winner of that election. Well, it is a common knowledge that when one is aggrieved about the outcome of an election, the first step is the tribunal. The second step is the Court of Appeal, and that is where they are at the moment. And so, we've heard in some quarters that the PDP will be proceeding to the Supreme Court. And so, everyone will keep their fingers crossed to see what happens in the next 2 months. From Abuja, the nation's capital, Best Orator reporting for BTV News.